Very good evening, dear friends, and we are back again in continuation of our lectures on the banking. Today, I will deal with some of the important banking legislations. This is also part of your syllabus. Friends, I will deal with the basics of the Banking Regulation Act, the Reserve Bank of India Act, and then the allied legislations thereon. Friends, as I told you, the entire banking system runs under the application of the provisions of the Banking Regulation Act 1949 and the Reserve Bank of India Act 1934. The Banking Regulation Act 1949, in fact, was called earlier the Banking Companies Act 1949, and the nomenclature was subsequently changed by the Banking Laws Application of Cooperative Societies Act 1965 and with effect from 1st March 1966. The Act was originally passed to consolidate and amend the law relating to banking companies, and then the enactment was amended in the year 2007 by the Banking Regulation Amendment Act and further amended in 2012 and subsequently in 2020 also with regard to cooperative societies. Recently the amendment has come. And then friends, this act is divided into 5 parts and 56 sections. Part 1 pertains to preliminaries like short title, etc., contains sections 1 to 5A. Part 2 consists of sections 6 to 36A and contains various provisions like the definition of bank, banker, banking or banking company, and so on. And Part 2A consists of section 36A to 36AC on the powers of Reserve Bank of India to remove managerial personnel and appoint additional directors. Part 2B relates to prohibition of certain activities in relation to banking companies under section 36AD. Part 2C contains section 36AE to 36AJ relating to the acquisition of the undertaking of banking companies. Then Part 3 relates to suspension of banking business and winding up of the undertakings of banking companies under section 36B to 45. Then Part 3 relates to special provisions for speedy disposal of winding up proceedings under sections 45A to 45(10). Then Part 3B contains provisions relating to certain specific operations of banking companies under sections 45Y to 45ZF. Part 4 pertains to miscellaneous provisions like penalties, etc., under sections 46 to 55A, and Part 5 relates to application of the Act to cooperative banks under section 56. This Act has 5 schedules containing various formats and details to be furnished by banking institutions. The second schedule was repealed in 1957. Friends, some of the important provisions now I will bring to your notice of this banking companies, the Banking Regulation Act 1949. This Act extends to the whole of India. Of course, now except Jammu and Kashmir is no more valid, so that will not come into picture. The Banking Regulation Amendment Act 2007 was brought into force to amend and providing for maintenance of percentage of assets, and section 35 of the Act pertaining to the powers of central government on the recommendation of the Reserve Bank of India to exempt by notification certain companies and laying of exemption notification in case of exemptions granted to institutions, banks, and says special economic zones. Then the 2012 Act was passed by the Parliament with a view to develop further the banking sector in India. And the salient features happen to be the banking companies are permitted to raise share capital by way of issuing preference shares in accordance with regulatory guidelines. Then the Reserve Bank of India is provided with more powers to collect information and inspect the associate institutions. The cap on restrictions on voting rights is increased. Prior approval of RBI was made necessary for acquisition of 5% or more shares or voting rights in banking company by any person. Then, primary cooperative societies are permitted to carry on the business of banking after obtaining license from RBI. RBI is empowered to supersede the board of directors of a banking company. Special audit of cooperative banks is provided by enlarging the scope of Section 30 of the Banking Regulation Act. The Reserve Bank of India is empowered to issue new bank licenses to corporate houses. As for example, during the year 2014, the RBI has given license to two corporate entities, Mumbai-based IDFC Bank Limited and Kolkata-based Bandhan Bank Limited. This is how it goes on. The monetary penalties which can be imposed by the RBI are increased, and a fund by name Depositor Education and Awareness Fund is created. And the Reserve Bank of India is empowered to transfer the money lying in the bank account which is not operated by the account holders or any amount remaining unclaimed for more than 10 years to the Depositor Education and Awareness Fund. And subsequently in 2020, with regard to cooperative banks, the power is vested with the RBI, and this particular amendment has come recently. And the provisions of Banking Regulation Act 1949 apply to different kinds of banks. And except Section 56, that is with cooperative societies, it applies to all banking companies, which are whether nationalized or not. Under Section 51 and 20, several provisions of Banking Regulation are made applicable to nationalized banks. All the provisions of Bank Regulation are not applicable to nationalized banks, of course. The Banking Regulation Act applies to cooperative banks also. Then, what is the scheme of the Act? This Act contains the provisions on the preliminaries like short title, etc. I need not go into that. Then the provisions relating to business of banking companies. Section 6 to 36A under Part 2 contains the various provisions under the Act relating to the form of business in which banking companies may engage, the definition of the term bank, banker, banking or banking company, prohibition of trading, board of directors, they are all dealt with under these particular provisions. Section 36AA to 36AC, Part 2A of the Act provide for control over the management of banks by the RBI. 36AD provides prohibition of certain activities in relation to banking companies. Then the acquisition of the undertakings of banking companies was provided under 36AA to AJ under Part 2C. Then the suspension of business and winding up of the banking business under 36B to 45. Special provisions for speedy disposal of winding up proceedings under 45A to 4510 under Part 3A of the Banking Regulation Act. Then the miscellaneous provisions 4650 to 55A under Part 4, 56 then under Section 56 exclusive zone to cooperative banks. Then there are different schedules, as I told you. In fact, this is the general scheme where you can go through these provisions more elaborately, including the 2020 amendment. And based on that, in fact, you can further proceed off. Then friends, I will also give a briefing on the Reserve Bank of India Act so that I need not deal with this again later on. And then the Reserve Bank of India Act actually was, it was brought into force in 1934. The RBI was established on 1st April 1935, the Central Bank of India. And then the preamble says that it is provided to constitute an RBI, that is the Reserve Bank of India, and says that whereas it is expedient to constitute a Reserve Bank for India to regulate the issue of bank notes, that is the most important, and the keeping of reserves with a view to securing monetary stability in India, and generally to operate the currency and credit system of the country to its advantage. And whereas in the present disorganization of the monetary systems of the world, it is not possible to determine what will be suitable as permanent basis for Indian monetary system, and whereas it is expedient to make temporary provision on the basis of the existing monetary system, and to leave the question of monetary standard best suited to India to be considered when the international monetary position has become sufficiently clear and stable to make it possible to frame permanent measures, this enactment has been brought into force. Friends, this act is divided into 5 chapters and 4 schedules. Of course, some sections and schedules 3, 4, 5 were repealed. There are several amendments also during year 2010. And then changes were made pertaining to joint mechanism of functioning of the bank by the RBI and the central government, the SEBI, the Insurance Regulatory and Development Authority, and the Pension Fund Regulatory and Development Authority. And Chapter 1 of the enactment, RBI Act, contains sections 1 and 2 pertaining to short title, etc. And Chapter 2 contains provisions under sections 3 to 19 pertaining to the incorporation, capital, management, and business transactions of the RBI. It also contains the provisions of the business which the RBI may not transact. Then Chapter 3 contains the sections 20 to 45 deals with the functioning of RBI, its obligation to transact government business and supplying different forms of currency, denomination of notes, forms of banknotes, etc. Chapter 4 contains the provisions under 45A to 45G dealing with the aspects relating to collection and furnishing of credit information. 3A, Chapter 3A deals with 45H to 45QB pertaining to provisions relating to non-banking institutions receiving deposits and various financial institutions. Chapter 3C deals with section 45R to 45T on prohibitions regarding acceptance of deposits by unincorporated bodies. Chapter 3D under 45U to 4510 sections, 45X, relating to regulation of transactions in derivatives, money market instruments or securities. Then Chapter 3E deals with section 45Y with aspects pertaining to joint mechanism of functioning of the bank by the RBI and the central government, the SEBI, the Insurance Regulatory and Development Authority, and Pension Fund Regulatory and Development Authority. Chapter 4 contains the provisions under sections 46 to 58A and deals with the aspects pertaining to general provisions like contribution by the central government to the reserve fund, other funds, tax exemptions, appointment and functions of the auditors. Then Chapter 5 contains section 58B to 61 and deals with aspects pertaining to penalties that can be imposed by the RBI on other banks and also the penalties that can be imposed by other banks on their customers. Schedule 1 contains information with where their local boards are to be constituted under Section 9 of the RBI Act. Schedule 2 contains the names of scheduled banks in accordance with Section 42, read with Section 2E of the RBI Act. Schedules 3, 4 and 5 were repealed as I told you. Now there are allied legislation to this Banking Regulation Act and the RBI. That is, one is the Negotiable Instruments Act 1881, the Recovery of Debts Due to Banks and Financial Institutions Act 1993, that is the DRT Act, then the Securitization, Reconstruction of Financial Assets and Enforcement of Security Interest, that is called SURFACE Act 2002, the Bankers Book Evidence Act 1891, then the Industrial Finance Corporation of India Act 1948, the Banking Companies Legal Practitioner Clients Account Act 1949, the Industrial Disputes, Banking and Insurance Companies Act 1949, the State Financial Corporations Act 1951, the State Bank of India Act 1955, the Subsidiary Banks General Regulations 1959, the Deposit Insurance and Credit Guarantee Corporation Act 1961, the Banking Companies Acquisition and Transfer of Undertakings Act 1970, and the Reserve Bank of India for Financial Supervision Regulations 1994. These are also equally necessary, my dear friends, to understand. That's the reason why I have given you a gist of these particular legislations. So in this session, we have discussed it with the basic legislations like the Banking Regulation Act and the RBI Act, and then other allied legislations which you must go through. Invariably, Negotiable Instruments Act you are supposed to read because that is part of your syllabus. Rest of the things for knowledge sake, don't forget Bankers Book Evidence Act, which has got a great impact on this particular subject matter. So with this background, dear friends, I request you to make out a good study and then come back to me. And in tomorrow's session, I will deal with the other aspects of our syllabus, which would be taken up one by one, and as fast as possible, we will try to complete it. Thank you very much, dear friends. Good night. Bye-bye.